Good evening, ladies and gentlemen. Welcome to the meeting of the West Whiteland Township Zoning Hearing Board. There is one hearing this evening, being the hearing of ARD Exton Square LLC. The applicant has filed a validity challenge to the zoning ordinance, to those portions of section 325-13.b and 325-13.c as amended by Township Ordinance number 484 to limit residential development in the town center zoning district to apartment dwellings at a maximum density of 6 dwelling units per acre of the gross lot area of the tract being developed. In addition, they have filed a challenge to section 325-13E5D and E5E, which state that an approved master plan for development of a tract in the TC zoning district shall not be amended within 5 years of its approval, and that an amended master plan shall not be further amended within 5 years of the most recent amendment. I've marked the following board exhibits for the hearing. Exhibit B1 is the notice of the hearing. Exhibit B2 is the proof of publication of the notice in the Daily Local News that ran on January 12th and January 19th. Exhibit B3 is the proof of posting of the notice on the subject property. Exhibit B4 is the proof of mailing of the notice to surrounding property owners. Exhibit B5 is a tax parcel map depicting the location of the property. Exhibit B6 is a November 21st, 2025 letter from counsel for the applicant, Mike Gill, regarding an extension for the hearing for this evening. Exhibit B7 is the zoning ordinance by reference. So tonight's a bit unusual of a proceeding than most of the members of the public are used to for the zoning hearing board. Tonight is a substantive validity challenge which carries its own sort of procedure under the municipality's planning code. We have a number of members of public here present as well as online tonight. So I'm going to make a couple of brief announcements and we'll talk about the process for how the hearings are going to go. So any member of the public has the right to be heard on the application tonight. You have the right to offer comments in favor of or against the application. You have the right to request party status in the proceeding, which, if granted by the board, permits you to present your own testimony and evidence. And generally speaking, it permits you to appeal the board's decision if you are dissatisfied with that decision. Relevant to our inquiry as to whether or not to permit you to be a party will be where you live in proximity to the property and whether or not you received a copy of the hearing notice in the mail. So at the appropriate time when we get down a little bit further in the hearing, I'm going to ask all of those who are requesting party status to identify themselves and where they live. The process for tonight, we're going to start and have a break probably around 8 o'clock. The board would like to end right around 9:30, depending upon where the parties are in their presentations. How this will proceed is the applicant will proceed with their witnesses and their testimony. Township, who is recognized as a party, will have the opportunity to cross-examine. Anyone else who has also been granted party status will have the opportunity to also question the witnesses. I'll probably instruct you on what that process is like at the time, and the board will have an opportunity for questions. Once the applicant has finished, the township will then have their opportunity to present their case, and we proceed similarly with cross-examination, and we will go down our list of parties if we have multiple parties. If we get to 9:30 and we're in the middle of testimony and you think you might be able to finish promptly, then we'll probably extend out to try to finish it tonight. If we do not finish the hearing tonight, then we have no other hearing scheduled for February's meeting, which I don't recall the date off the top of my head, but what we would do is continue it to that date and we would come back in a month. Lastly, what tonight is not about, and I want to make sure everyone's clear on that, are the plans that were presented by the applicant and the action that the Board of Supervisors took on those plans. That has a completely separate, different process. for appeal and argument than what is in front of the zoning hearing board tonight. You may hear testimony as it relates to those plans and to the actions taken by the township. But what tonight is about is whether or not the ordinances that have been identified by the applicant are valid or not. So that's what we're going to hear testimony and evidence about. So for anyone who becomes a party, just understand if there's objections because the types of questioning that you're going into, there will be a different process that will involve those land development plans at some point, I presume, by the applicant, but that is not necessarily what's in front of us tonight. All right, so why don't we identify counsel for the parties, please, for the record.
There we go. Good evening, members of the board. McKenna, my name is Michael Gill. I'm an attorney with the law firm Hamburg, Rubin, Mullen, Maxwell, and Lupin, and we have the privilege of representing ARD Exton Square LLC. Seated to my left is my co-counsel, Mark Kaplan, with the law firm Kaplan Stewart. Mr. Kaplan is our witness here this evening, but he is also counsel of record for the applicant.
Thank you.
Good evening, board. My name is Alex Baumler of Kill County Law LLC. We are the appointed solicitor for West Whiteland Township. And seated to my right is John Walco, also of Kill County Law.
Good evening.
Thank you, gentlemen. So, Mr. Gill, would it be your preference at this point to make an opening, or would you like me to run through requests for party status?
Well, we do have a discussion to be had with regard to party status. This being a challenge to the validity of the ordinance, the only real party in interest is the township. In order to have party status as not either the applicant, the challenger, or the township, somebody would have to establish that they are affected by the application. As you just pointed out, the nature of this application is the validity of the ordinances, not the underlying development that ARD Exton Square proposes for the Exton Square Mall property. With that in mind, and given the nature of the application, again, as you just pointed out, we don't know how anybody other than the township could be affected by the board's resolution of this challenge. So with that in mind, I don't know if anybody's going to ask for party status, but we would object to party status other than, of course, the township.
That's fair, and I appreciate your argument, but I think I'm obliged to ask if there are those who request party status, and the decision, I think, is ultimately up to the board whether or not to grant it.
Of course, understood.
Okay. So having said that, let's start with this side of the room. Again, what I'm asking now is whether you'd like to request party status. And the applicant is going to object no matter what to what I'm hearing is to anyone who asks for party status. The board and I will discuss whether or not to grant those requests. But what that will allow you to do, again, if granted, is to question the witnesses or to testify and offer your own evidence. If you simply want to observe or you want to offer public comment, you will be given that opportunity. Once the close of the testimony and evidence occurs, and I don't know if that will be tonight or if it will be next month, any member of the public will be given the opportunity to be heard and to make a statement. So, starting on the right-hand side, is there anyone who is requesting party status? I'm not seeing anyone on the right-hand side. Is there anyone on the left-hand side that's asking for party status? Okay, and then online, Patrick, has anyone got their hand up to request party status or to be heard?
Yes, if you're requesting party status as a part of this hearing tonight, and you receive notification for this particular hearing, please raise your hand and you'll be recognized. Once you're recognized, please address your name and your address for the record. I do not see anyone.
Okay. All right. So I'm going to presume then, having been given the opportunity, that the only parties will proceed as the applicant in the township. If there's nothing further from council, Mr. Gill, I'll turn it over to you to begin your case.
Thank you very much, Mr. McKenna. As I noted earlier, my name is Michael Gill, and again, along with Mark, I have the privilege of representing ARD Exton Square LLC, which is the owner of the Exton Square Mall property and the challenger in the challenge which is before the zoning hearing board this evening. That challenge is what is marked in the exhibit binders, which I passed up to you all before the hearing as Exhibit A1. It has certain subtabs, A1A through A10, which we'll be identifying as we move through this statement. There are other exhibits in the binder, of course, all the way up from A2 to A17. And Mr. McKenna, as I pointed out earlier, I passed up to you a single copy of A18, which is the deed for the property, identifying ARD Exton Square LLC as the current owner of the Exton Square Mall property. Members of the board, for many decades, Pennsylvania land use law has recognized that a municipality may not lawfully enact a zoning ordinance for the sole purpose of preventing the legal use of land under an existing ordinance. Such an ordinance, when it is enacted and directed at a specific property, is called special legislation, and it's illegal. Because that site-specific targeted result is precisely, and indeed, as you will hear this evening, expressly what the township attempted when it enacted ordinance number 484 in February of 2025. Ordinance 484 is substantively invalid as a matter of law. We're asking the board, the zoning hearing board this evening, to acknowledge that invalidity. We're also asking the board to declare invalid section 325, 13E, 5D, and E5E of the zoning ordinance. On their face, those sections of the zoning ordinance prohibit amendment of an approved master plan within the town center zoning district for a period of 5 years following approval or once having been amended following that amendment. Those provisions work a moratorium on development. They tell a developer that once you have an approved master plan, you cannot make changes to that plan for a period of 5 years. You are locked in to that master plan approval. Again, that works a moratorium on development, which in Pennsylvania is per se illegal. How did we get here? As I said, ARD Exton owns the approximately 74-acre collection of parcels right out of this window, known commonly as the Exton Square Mall. In your binders at Exhibit A2, if we do need a visual representation of the mall, for anybody sitting in this room, is an aerial view of the Exton Square Mall property highlighted in red. That property is in the TC Town Center zoning, mixed-use zoning district. And pursuant to section 325, 13E of the zoning ordinance, in that district, parcels which are 10 acres or more in size must be developed under an approved overall master plan. At Exhibit A3 in your binders is the Town Center zoning district regulations excerpted from the zoning ordinance. As they stood from April 22nd, 2020, through February 12th, 2025, a date which will become very important as we move forward. Those regulations in Exhibit A3 allowed for multifamily dwelling units and apartments and limited density in the town center district for such uses, not based on a hard and fast formula, but rather as a factor of the size of a property and application of otherwise generally applicable area and bulk criteria. In other words, if you had 10 acres and you applied the area and bulk criteria to those 10 acres, the density that you could build your property out to was based on that rather than X number of units per acre. Now, as all of us are surely aware, the Exton Square Mall is, to be charitable, failing to thrive. ARD Exton intends to redevelop that property as a true mixed-use town center development containing a balanced blend of residential, retail, office, entertainment, civic, institutional, and recreational uses. And as the township staff itself confirmed, as you'll hear throughout our presentation this evening, that development that ARD proposed is consistent with the purpose and intent of the town center zoning district. both before it acquired the property and since it acquired the property, ARD expended an incredible amount of time, effort, and resources to design the master plan that is required under the TC zoning district regulations. Those efforts included an extensive review of the township's ordinances, extensive discussion, planning, and coordination among ARD Exton's team of civil engineers, land planners, architects, landscape architects, and traffic engineers, not to mention lawyers. The result of those efforts is a coordinated, pedestrian-friendly master plan for the property, which again, as the township itself confirmed, complies with the provisions of the TC district as they stood at the time the ARD submitted its master plan on February 10th, 2025, 2 days before the enactment of Ordinance 484. Now, in early January of 2025, as that extensive planning process was maturing to the point where we were ready to submit plans, and in order to finalize that planning process, we reached out to the township. We approached the township to discuss the master plan, and the township was already aware that there were public rumors that something was about to happen at the Exton Square Mall property. On Friday, January 3rd, 2025, Mr. Kaplan telephoned Mr. Weller, the Director of Planning and Zoning and the Township Zoning Officer, and during that telephone call, Mr. Kaplan and Mr. Weller discussed the master plan and the requirements at Section 325.13 of the ordinance. Mr. Kaplan expressly informed Mr. Weller that the master plan included various types of residences, including multifamily and including apartments. Mr. Weller and Mr. Kaplan arranged for ARD's team to come in and meet with township staff the following week, a meeting which took place on Wednesday, January 8th, 2025. Now, as the testimony and the evidence which will be presented this evening will show, contemporaneously with ARD's efforts and the township being informed of ARD's plans, the township engaged in a calculated, deliberate, and targeted scheme to prevent ARD from proceeding with any redevelopment of the property, which includes the type and density of residences which were permitted under the zoning ordinance through February 12th, 2025. Specifically, from early January through February 12th, 2025, the following occurred. The township directed staff to initiate the process of amending the zoning ordinance, Section 325.13, to revise the regulations addressing residential development in the town center zoning district. Even before any such amendment was drafted, the Board of Supervisors passed a resolution scheduling a hearing on an as-yet undrafted ordinance just so they could get that ordinance adopted as soon as possible. Staff then drafted such an ordinance, a copy of which is in your binders at Exhibit A4, the draft ordinance. The township advertised notice of a hearing to be held on February 12th, 2025. Copies of that notice are in your binders at Exhibit A5. Then, as required, the Township Planning Commission considered the proposed ordinance. Now, the Township Planning Commission had some questions. Why are we rushing this? We have suggested changes to the proposed zoning ordinance. And at that meeting, Township staff and one member of the Board of Supervisors said to the Planning Commission, we don't have time to wait. We have to get this done. Why such a rush? Well, as one of the supervisors noted, the township had to rush, quote, given the nature of the plans that were coming up. What plans were coming up? The plans that the township knew about with regard to the Exton Square Mall. As required, the township submitted the proposed ordinance to the Chester County Planning Commission. Chester County Planning Commission responds saying, hey, wait a minute, your town center district is all about high density. This is where you're supposed to put all of your high-density development. That's what the purpose and intent of the ordinance says. Maybe you should take a step back. Maybe you should consider some of the comments that we're making here out the window. Township says, thank you, CCPC. Thanks for your comments, but no thanks. Then finally, on February 12th, 2025, the Board of Supervisors holds a hearing and adopts ordinance number 484, which is in your binders at Exhibit A6. I will repeat, all of this was done under the cloud of what township staff unabashedly described as, quote, a direct response to concerns we've heard from residents. To be honest, it is the mall property that everyone's concerned about. That is a direct quote from township staff member at the Planning Commission meeting that I mentioned a moment ago. Any fair and impartial review of the evidence which ARD Exton will present in this hearing will confirm that the township contrived and rushed through Ordinance 484 with the express and specific purpose of preventing ARD Exton from developing the property in accordance with the Town Center District regulations as they stood since at least 2020. As such, as I mentioned a moment ago, Ordinance number 484 constitutes special legislation directly aimed at the Exton Square Mall property and is therefore on its face substantively defective and invalid. And why does all this matter? You're going to hear, and Mr. McKenna alluded to it, about the master plan application that ARD did submit, and that went through a review process. It went through a review process with township staff, with township consultants, with the Township Planning Commission, and ultimately there was a hearing in front of the Board of Supervisors in the fall. Township staff and the township consultants concluded universally, that the application complied with the objective criteria applicable to master plan applications as they stood on the date that the application was filed, February 10th, 2025. On March 14th, 2025, Mr. Weller issued a memorandum in which he confirmed that ordinance number 484 could not be applied to the master plan. We've included a copy of that memorandum in your binders as part of the challenge at Exhibit A1I. At Exhibit A1J of your binders, you will find a copy of another memorandum which Mr. Weller issued dated August 15th, 2025, in which he states, quote, the zoning officer has further determined that this project complies with the applicable standards of Section 325.13C and Section 325.13D. At Exhibit A1K of your binders, you'll find a review memorandum from Township Planner Ed Therakoff of Therakoff Design, in which he determined that, quote, the architecture precedent imagery on the plan set demonstrates conceptual compliance, the very level of compliance which is required under the ordinance for master plan approval. At Exhibit A1L of your binders, you'll find a copy of a review letter from Spot Stevens and McCoy, the township engineer, in which they determined, quote, as a result of the meeting, a meeting which they had with ARD's team, it is our opinion that the stormwater management concept as currently presented demonstrates that the detailed design to be completed during the land development plan approval process will be capable of meeting the applicable provisions of the West Whiteland Township Stormwater Ordinance, the very level of compliance which is necessary under the ordinances for master plan approval. Master plan hearing then happens in the fall. The Board of Supervisors held that hearing over 3 nights between September 24th and October 22nd. Notwithstanding the voluminous record of that hearing, all of the confirmations from township staff, all of the confirmations from the township's consultants, 2 members of the Board of Supervisors who remained on the board at the end of that hearing voted to deny the master plan application. In fact, one of the supervisors stated that he is concerned about the residential density of the proposed redevelopment, and he repeated those statements regarding the residential development in an interview which he gave with the Philadelphia Business Journal. And a copy of that is included in your binders at Exhibit A1N. Now, we're appealing that denial to the court. We have both an appeal and a separate lawsuit going with regard to the denial. Here's why this hearing matters. If that denial somehow stands, and of course we don't expect that it will, but if it does, the township's targeted and unlawful assault on ARD's legal rights to develop the property will be complete. Because if that denial stands, Ordinance 484 becomes applicable to any future redevelopment of the Exton Square Mall property. That is why all of this matters, and that is why we're here tonight. Now, the second part of our challenge, again, goes to the facial illegality of the 5-year moratorium. The Pennsylvania Municipalities Planning Code, which governs all of this, contains no authority for municipalities to impose a moratorium on development, either temporary or permanent. On October 27, 2025, Supervisor Dunn made comments in a call-in to a WCHE morning radio show that indicate his intent to weaponize the 5-year moratoria prescribed in the zoning ordinance to further meddle with ARD Exton's private land ownership rights and to further stifle ARD's constitutionally protected rights to develop the property. We've included a copy of that at Exhibit A10 of the binder. So we're here tonight, as Mr. McKenna said, on a proceeding that is rather unusual. The Zoning Hearing Board typically will hear applications for variances, applications for special exceptions, maybe a substantive validity that challenges an exclusion of a use from the township. What we're here about tonight is something slightly different. What we have here is a targeted attempt by the township to deny ARD Exton of its rights to develop a specific property according to ordinances as they were in effect when that application was filed. If the board does not have any questions, we're prepared to proceed into Mr. Kaplan's testimony.
Thank you, Mr. Gill. Does the township care to make an open?
Yes, just briefly. Quite frankly, I'm a little confused. We heard Mr. Gill say that this is about the validity of the ordinance, not the underlying development. We heard Mr. McKenna start off by saying that this is not about the ARD Exton plans. This is not about the actions of the Board of Supervisors. And then we sit here for 15 minutes and hear about the actions of the Board of Supervisors and the plans that were filed in this matter. It's clear that they're trying to have this zoning hearing board be a superior appellate court of the Board of Supervisors and take a second bite at this apple. This is not about the plans that were filed. This ordinance originally was amended in 2020. That's when the master plan concept came in. And if you haven't noticed, for the last 5 years, residential development has been getting pretty increasing here in the township. And it's been a concern for the Board of Supervisors, the newly elected Board of Supervisors, for a very long time. And what these ordinances do is attempt to fulfill the concept of the town center. It's a mixed use. That's not all residential. You're going to hear from Mr. Weller as to why he and his planning team came up with these concepts. Good planning concepts. Concepts to support the town center, to get the mixed use. Concepts that stop piecemeal development and have good planning principles that the entire large properties, mind you, not a 75-acre property, 10-acre property is where this ordinance applies, which applies to many different properties within the town center. Why this ordinance, both provisions were put in to address these general planning concerns. As this board knows, a zoning ordinance is presumed to be constitutional. And the law states that when validity is debatable, it's the legislature's judgment, the board's judgment, that must control. So I'm happy to hear tonight about what's in the ordinance. But I don't want to be annoying on this, but as this night, if we're going to keep hearing about decisions that were made related to this plan, I'm going to be continuing to ask for office of proof as to the relevancy related to the ordinance itself. Thank you.
Thank you. Mr. Gill, please call your first witness.
Our first witness is Mark Kaplan.
I do.
Mr. Kaplan, would you please confirm your name and your business address for our record?
Yes, Mark Kaplan. My business address is 910 Harvest Drive, Blue Bell, Pennsylvania.
And Mr. Kaplan, you are a licensed attorney in the Commonwealth of Pennsylvania, correct?
For 55 years.
And what is your primary area of practice?
Land use.
And would you give us, even after 55 years, would you give us a brief overview of your educational background?
I have a degree in accounting from Temple University. I have an LLB from Villanoma cum laude. I was a member of the law review. I was a clerk at the United States Court of Claims, and I've practiced in Greater Delaware Valley for 55 years. And I'd say that 95% of what I do is involved in land development. I represented the developer of the Main Street at Exton, across the street, which included the conveying to this township of the property on which this building is constructed. That was 25 years ago, and I've been involved in many significant land developments, subdivisions, apartments, warehouses, just about any type of development that requires a permit or an approval.
Thank you very much, Mark. We're all, I think, familiar with Mr. Kaplan, and he's going to be testifying this evening as both a fact witness, and I'll offer him as an expert in the field of land use law.
I'm going to object to the expertise in land use law. It seems to me that would be going to the ultimate issue, which would be the issue that this board needs to decide. I have no objection to a fact witness based upon the representation, but if he's going to be testifying that, well, I'm an attorney representing his client, by the way, and my client is right, then I submit that that goes beyond just credibility or the weight of the evidence, but that is not appropriate in this matter. The ultimate issue is for this board to decide.
Mr. Kaplan will not be offering any opinions on the ultimate issue. He will, however, be asked and offering conclusions regarding the nature of the zoning ordinance and what uses were permitted at a given point in time.
All right, if he's not going to be offering opinion as to the ultimate issue, then I think we can go ahead and admit him as an expert, but I'm probably going to potentially hear from Mr. Walko on future objections as to the scope of that testimony, and we'll deal with him at that time.
And again, I have no objection with him testifying as to his involvement and reading what the ordinance says, which it seems like that's what we're going to be getting into.
We may do that, and we may be a little bit farther than that, and we'll proceed. Excuse me, Mark. Mark, are you familiar with a business entity known as ARD Exton Square LLC?
I am.
And do you have a relationship with that business?
I represent that business, and we formed that business, that LLC.
Okay, when you say you represent them, you serve as counsel for them with regard to transactional issues and land use issues, correct?
We do.
Okay, and have you represented ARD Exton Square LLC? I'll just call them ARD or ARD Exton from this point forward. How long have you represented that entity?
Since that entity was created, and have represented the principals for many years before that.
All right. So does that time frame include the time frame in and around January of 2025?
No, absolutely.
Now, given that you represented ARD Exton during that time period, could you please tell us about your personal involvement in ARD Exton's efforts to redevelop the Exton Square Mall property?
Certainly. So, prior to the application being made, and for probably 8 or 9 months prior thereto, I advised ARD and its principals on just about all legal considerations of its purchase of the property from Preet and the proposed redevelopment. Once we had tied the property up under an agreement of sale, we moved full scale into the design stage. And I was probably the coordinator of all of the various professionals that were involved with the development of the plan. The civil engineers, the urban planners, the traffic engineers, the landscape architects, and probably the geotechnical engineers and some of our construction people. I coordinated the interaction of all of those people so that we were all on the same page and everybody was fully informed as the plan evolved over 8, 9 months, maybe 7 months by the time we got to January. I was also primarily responsible to make sure that the plans for the redevelopment of the mall complied with the county, state, and federal regulations, and at that time, primarily the ordinance and rules and regulations of this township. When we got to the point in January that you talked about, Mr. Gill, where we had come to the conclusion that we had at least preliminarily landed or finalized an overall plan for this mixed-use town center, which, Mr. Walko, also includes significant amount of non-residential development. It was my job to coordinate, be the liaison with the township. Obviously, because of my involvement in Main Street at Exton, I've known John Weller for a long, long time. In addition to anything that I missed, I gave general legal advice to ARD as the owner and proposed developer of the mall, the existing mall.
All right, so as what I'll describe as general counsel for ARD and its intentions with regard to the Exton Square Mall property, is it fair to presume that you conducted an in-depth review of the township's zoning ordinance as it stood in the fall of 2024 going into 2025?
Many times.
In particular, did you review the provisions of Section 325.13, which were applicable to the town center zoning district?
Yes, that is the town center district, and I reviewed it many times.
All right, you have a copy of the exhibit binder there.
I do.
All right, and members of the board, again, those are the regulations that are excerpted at Exhibit A3. When you reviewed the zoning, the town center district zoning regulations in the time frame that we just described, were multifamily dwellings permitted by right in the TC district?
Yes. Now, I should say, and maybe you'll get to it, but in this ordinance, multifamily dwellings cover a whole group of residential products, apartments, townhouses. I think it talks about quads, may even talk about two-family homes. But the definition of multifamily is multifaceted.
I was about to get to it. Would you please turn your attention to Exhibit A7?
A7. Okay.
Do you recognize that document?
Yeah, it's the definitional section out of the West Whiteland ordinance.
All right, and does that include a definition of multifamily dwelling units?
It does.
Would you please just read that definition into the record for us?
So that's subsection C, Article 2, terminology, Section 325-8, definitions. A, single family. B, two family. C, multifamily.
All right, and what is multifamily according to the West Whiteland Township Board of Supervisors as reflected in this zoning ordinance definition?
A building containing 3 or more dwelling units, comma, including comma, but not limited to fourplex, paren, quadruplex, end paren, townhouse, paren, single family, comma, attached, end of paren, comma, apartment buildings, and other similar building types.
All right, so multifamily uses, including all of those types of multifamily uses, were permitted in the town center district by right prior to February 12th, 2025, correct?
Correct.
At the time of your review, again, the time frame that we're talking about here, summer and fall of 24 into January of 25, did the zoning ordinance contain any limitation on density other than as you would arrive at a number based on the area of the property and the application of area and bulk criteria?
So let me say it a little differently.
Please.
The town center ordinance permits a wide range of uses, and you are correct, it contained no limitation on density, as you would see in some ordinances that you could have X number of townhouses or X number of apartments per acre. That's not the way this ordinance was constructed by the township.
All right. During this time frame, again, the time frame we're discussing here, summer, fall 24 into January of 25, were you aware of any pending or proposed amendments to the town center zoning district regulations?
Absolutely not.
And during that same time frame, were there any ordinance-based or otherwise prohibitions on multifamily dwelling units within the town center zoning district?
No. Other than you had to go through the process you talked about before, starting with a master plan and then a land development plan and then a final plan.
All right. So again, not to belabor the point, but during the entire time that the ARD Exton Design and Development team is working on the master plan as required under the ordinance, that all of that work is being done under the construct of an ordinance that allows for multifamily dwelling units without a formula-based density limitation, correct?
Let me say it in a little different words. In reliance on the fact that multifamily, and that's the panoply of apartments and townhouses, in reliance on that, if I can digress, I've been involved with this mall for probably 8 or 9 years. I was involved in attempts to redevelop it. And this mall was extremely, extremely difficult to redevelop economically. And my client came up with the idea to do exactly what the ordinance says. And we'll get to that definition in a minute, but to have a true mixed-use town center, sometimes said to be live, work, and play in a community. And there was no economic way that this mall could be redeveloped without a significant portion of living space so that it could be what the ordinance says, an integrated town center.
All right. Now, this time frame that we keep referring to, as I've described it, reaches a crescendo in January of 2025. By that point in time, had ARD Exton developed a draft of its master plan?
Well, yes, but a master plan was not one sheet. It was in excess of 40 sheets. It was a huge amount of engineering. When the ordinance was adopted or amended in 2020, I think it was said already, but I was there, I heard it, to stop Preet from selling off the mall in pieces. The master plan concept is not one sheet, as I said. It is very, very significant design criteria. For instance, you have to demonstrate that you comply with the zoning ordinance. So on 75 acres with multiple buildings and roads and garages and everything, the engineers had to lay out all of those elements in exacting detail because we had to meet all of the requirements, side yard setbacks, all of that stuff. So we did get to that point, and I think that's where you asked me before I digressed, was yes, in January, we got to the point where we had done an enormous amount of work, and we were satisfied that we had a plan that complied with the ordinance requirements, and it was time to engage with the township to start that process.
All right, and all of that work, that crescendo that I described, you described slightly more eloquently, is that what is reflected in Exhibit A10? If you want to take a look in your binder there.
I think this is, let me look through it. This is, I'll call it a synopsis of the plan. This is the engineers and architects and I extracted from whatever the number of sheets, I think was in excess of 40 sheets. We extracted these sheets so that we could present them in this room. Yes, the answer to your question is yes, but we don't have all of the nitty-gritty detail drawings that follow up most of these. Some of these single sheets are really one of 3 or even 4.
Understood. Understood. So to clarify, or confirm, excuse me, your testimony is that Exhibit A10 is
A
a
representation.
representation of the total master plan set.
Correct.
All right. Now, having reached that crescendo, having done all of that work, you said a moment ago that the team decided that it was appropriate at that point in time to engage with the township, correct?
Right.
All right. And did you contact Mr. Weller, whom you said you've known for years? Did you contact him to start that process?
I did.
On what date did that occur?
The 3rd of January.
2025.
Correct.
That was a telephone conversation, correct?
It was.
Would you please describe for the board the substance of that conversation?
I called John and I said, John, this is the call you have been waiting for. And he laughed. You're talking about the mole. And I said, yes. And then I've made some notes of the things that we talked about. I really went into detail. Quite frankly, I was very excited about what we had put together. And I've worked on a number of these failing malls, and they have been really, really, really difficult to redevelop. The economy had sort of come around, retail had sort of come around, and Peter Abrams had some brilliant ideas. And I was excited to call somebody I consider a friend, professional friend, and say, we've got something really good for you. So what did we talk about? This was not just a call, John, I want to come in and show you our plans. I talked about the overall redevelopment plan for the mall, the mixed use factors of that. The fact that with the exception of 2 buildings, the Boscop building and the structured garage in the back, everything had to come down. The mall, many people don't realize that the mall is built on 2 different levels. And there is a huge retaining wall in the middle that supports it. And that has to be totally redone. And I talked to John, I think about that. And then talked about the master plan filing requirements for the master plan that we have put together. The ordinance was somewhat unclear because in this township for years, anything over 10,000 square feet had to be permitted by conditional use before you can go to land development. Well, the master plan was sort of thrown in on top of that to require the owner of the mall to do something in a coordinated fashion. Okay, what was it? How does it fit in with the conditional use? I read the provisions a number of times. I wasn't really clear. I believe that John and I talked about it that day. It's a hybrid. The master plan is a 3rd step in what is usually a 2-step process. It's sort of a conditional use, but it's not a conditional use in that it gets processed as a conditional use, meaning the hearings, but you don't have all of the requirements of the conditional use that you normally have. You don't have to have a traffic report, as an example. And then I'd explain to John, and we've explained it any number of times, Mainline Health is a tenant in an interior building of the property. And hopefully we were moving Mainline Health and they were going to continue to be a tenant in the building, and we think they will be, causes a big problem time-wise, because in order to get in and do the demolition on a lot of this, we have to create Mainline's replacement space and get it built before we can move Mainline out. And at that time, we were talking about putting Mainline on a pad on the corner. So John and I talked about the technical ways of how we could expedite that. And John specifically asked me, I think really the same thing he'd asked me when we're in for Preet. There's a lot of rumors floating around. Would you hold a public presentation? And I said, yes, we certainly would. And then we scheduled another meeting for 5 days later, I believe.
All right, now Mr. Weller referred to rumors, and you understood that to mean rumors specifically about the mall, correct?
Yeah, rumors about the mall. I don't know what the rumors were, but there were rumors about the mall.
My question, Ms. Mark, is the conversation that you just described with Mr. Weller was exclusively about the mall, correct?
Yes.
Okay. All right. So this was no short conversation, correct?
It was not.
All right. And after the conversation that you had with Mr. Weller, did you memorialize the substance of that in an email to members of the ARD team?
I did.
And would you please take a look at Exhibit A8?
It is. That's my email. Friday, January 3rd at 2:52 in the afternoon.
All right. And in that email, you report to your client and to other members of the ARD team that you had a great conversation with John. I'm assuming that is referring to Mr. Weller, correct?
Yes.
All right. And you referenced there that you set up a subsequent meeting with Mr. Weller and other representatives of the township, correct?
Correct.
Is that the meeting to which you referred a moment ago that happened 5 days later on January 8th?
Correct.
All right. Would you please take a look at Exhibit A9? What is that?
Oh, that's my email also. Did it Friday night at 10 o'clock. Confirming with John that we would have a meeting. In fact, I even said that Tom King of NVR is Ryan Holmes, will be coming from another meeting, and can we change the time? So John was well aware that we were having a home builder as part of our team.
Okay. And of course, your understanding is that Mr. Weller would recognize Mr. King's name as being associated with NVR Homes.
I believe so.
Okay. Now, this meeting that occurred on January 8th, the following Wednesday, who attended that meeting?
So it was Peter Abrams, Seth Shapiro, me, Township Manager Pam Rule Bear, Pat Gorman over here, John Weller. I think that was it.
Okay.
I think that was it.
And that meeting took place here at the Township Building, correct?
This room.
In this very room. And during that meeting, did you and other members of the ARD team describe the proposed redevelopment of the mall property to the township representatives?
Oh, Seth Shapiro did. It was his baby. He had designed it, knew every in and out of it. had a drawing of it, and made a presentation to the group that was there.
All right, and that the substance of that presentation, was that consistent with what you described a moment ago about intending to demolish all but 2 of the buildings, move forward with multifamily and apartments, and to turn the property into a walkable town center?
More than just apartments and townhouses. A huge component of this redevelopment is retail. It's medical. It's a wellness facility or a gym. It's the hospital MOB. It's office space. And it's a great deal of public open space in the middle. It was not an apartment or a townhouse community. It was a mixed-use town center, exactly what the ordinance says is supposed to be here.
All right, when you say what the ordinance says is supposed to be there, I want you to take a look at the first page of Exhibit A10. That contains a passage of building a pedestrian-oriented mixed-use town center. You know where that text comes from?
Yeah, I know where it came from.
Tell us.
Seth and I pulled it right out of the purpose or the intention section of the town center ordinance. Build a pedestrian-oriented mixed-use town center inclusive of residential, retail, office, institutional, and recreational uses, which will serve as a focal point for West Whiteland Township. I think the ordinance is 99.5% says the same thing. We could check it, but I'm sure it's just about identical.
All right. Would you please turn your attention to the second to last page of Exhibit A10? And again, I just want to confirm, A10 is the packet that the team had with it at the meeting on January 8th, correct?
I'm not sure if we had the whole package or we had an overall plan, but I believe that we gave this whole package.
Okay.
Sorry, Mr. Gale, I'm sorry. You're referring to the sheet that's shown on the screen right now?
No.
Looks like it's referred to as drawing number 8 of 9, down in the bottom left-hand corner.
That's correct, Mr. McKenna. It bears a date of January 7th, 2025, and it's entitled Conceptual Land Use Plan.
Right.
So I'm sorry, your testimony is that this packet and something that showed the various land uses within the master plan was presented to the township on January 8th, correct?
Absolutely, and I believe it was this drawing because this shows all of the uses.
All right, and again, clear on this is a depiction of uses described as residential, correct?
Correct.
All right. Did you leave a copy of that conceptual plan with the township staff at the January 8th meeting?
We did.
What happened next? What happened after the January 8th meeting? Well, let me take a step backwards. Did something happen at the end of the January 8th meeting that caused alarm?
Yes. Don, I forget exactly the words, but it was something that I have a bomb for you or something like that. And what is it? Well, the supervisors don't want a lot of residential here.
Okay. But again, at the risk of belaboring the point, on January 8th, 2025, the ordinance, as it existed at that point in time, allowed for multifamily development in the town center district, correct?
Correct.
Having heard that statement from Mr. Weller, what did the ARD team do next?
Well, we quickly found out, and I don't believe it was through the people in that room, that on the 6th of January, a Monday night, after the 3rd, at their reorganization meeting, unusual for a board to take action, a reorganization meeting, they passed some type of resolution, and I'm sure that you're going to get into it, but basically saying, let's get going so that we can stop this.
All right. Before we get to that resolution, I want to revisit January 3rd, 2025. Would you please take a look at Exhibit A11?
A11. Go ahead, I have A11.
All right, now that's dated January 3rd, 2024, correct?
Correct.
Is it your understanding that that's a misstating, that it's actually January 3rd, 2025?
Oh, there's no question about
Okay, and if you take a look.
There's no objection to that, too.
Okay.
Our understanding as well.
Thank you.
All right, now this is a memorandum dated January 3rd, 2025, the same date that you had reached out to Mr. Weller to talk to him about the mall property, correct?
it. Correct.
All right. I'm assuming you've reviewed this prior to this evening?
I have.
Can you tell us what it says?
I'll just make one other comment before I get into it, that we were not given this on January 3rd. We got this through a right-to-know request. So John goes through the background. It'll be easier if I read it. Town Center Zoning District was created to allow a mix of residential, commercial, and office-type uses at a higher density than allowed elsewhere in the township to facilitate a walkable community around the intersection of Lincoln Highway and Pottstown Pike. Since 1998, the town center regulations have allowed a combination of permitted uses on a single lot, establishing limits on building height and impervious cover, along with minimum building setback requirements, just like any other zoning ordinance. What was unique about the TC regulations was there was no stated limit on residential density, an approach known as, quote, form-based code, end of quote. That is, the regulations limit only building size, semicolon, a residential building may include as many dwelling units as will fit in the allowed building envelope. Current paragraph, the current TC regulations are in Article 4 of the zoning ordinance, and they retain the form-based philosophy first used in 1998. In addition to a wide variety of commercial and institutional uses, current regulations allow multifamily buildings, i.e. apartments and townhouses, but no other residential types. The regulations specifically permit a single building to include both non-residential uses and apartments, although in such case, residential use may not be on the ground floor. The TC provisions have served us well, allowing for the redevelopment of a number of properties for high quality, high density development at the best location in the township for denser development. However, the current high demand for housing of all types has led to a concern that what was intended to be a mixed-use area may become more residential to the exclusion of the non-residential uses necessary for a vibrant community. Staff and the Planning Commission will develop an amendment for the board's consideration that will address this concern.
All right. Now, again, you testified earlier that throughout the summer and fall of 2024, you had been aware of developments within the township with regard to proposed ordinance amendments, discussions about changing the ordinance. During that,
Wait a minute. Say that again. I
You were-
wasn't aware of changes to the ordinance.
I'm sorry, your testimony was that you were aware that there were no proposed changes.
Exactly.
That's what I'm asking. All right. So the first time that you heard about a potential change to the ordinance was at the January 8th meeting, correct?
Correct.
Notwithstanding the fact that on January 3rd, Mr. Weller had prepared the memorandum marked as Exhibit A11.
That's correct.
And again, January 3rd was the same date that you reached out to Mr. Weller to tell him about ARD Exton's plans for the mall, correct?
That's correct. But just so it's clear, we were not given a copy at the January 8th meeting of this memorandum that Mr. Weller had prepared the previous week, same day we met.
Okay.
We didn't know how far this idea of cutting back on residential had gone.
All right. Now, would you please turn your attention to Exhibit A12? Do you recognize that?
I do recognize it.
All right. And can you tell us what it is?
My understanding is that it is a resolution that was adopted on the 6th. Very unusual resolution. Says, and whereas proposed amendments to Chapter 325 zoning regulating residential development in the Town Center District will be considered by the Board of Supervisors in a public hearing at their meeting on February 12th. And then they authorize a public hearing on February the 12th, but they don't tell you what the ordinance is, what's going to be considered. So they rush to grab a hearing date as quickly as
I'm going to
they could.
object to speculation at this point.
Well, we'll get to the understanding, the witness's understanding of why this was, or how this was rushed in just a moment. We'll come to that.
Okay, thank you.
In any event, they scheduled a hearing for 5 weeks, 4.5 weeks after the date or the night on which they authorized the scheduling of a hearing to change the zoning on us.
Is it your understanding, based on your experience and expertise, that sometime in or about the middle of February would have been the earliest legally possible date for having an ordinance amendment hearing if that process started at the beginning of January?
Absolutely, and in another memo that you'll get to from Weller, he says that you'll have to send the proposed ordinance to the 2 planning commissions, township and the county, 30 days in advance of the date of a hearing. So if you're scheduling this hearing on February the 6th,
Or 12th?
no, scheduling it on January 6th for a hearing on February the 12th, and you don't even have an ordinance yet to send to the Planning Commission, it cannot legally be done any quicker than this.
Okay. The board authorizes staff or authorizes the scheduling of a hearing for an as-yet unprepared ordinance.
Correct.
Would you please take a look at Exhibit A13?
I have it.
Do you recognize that?
Well, this, we issued a right to know request to the board, and we received this memo, I believe the memo from John on the 3rd. Yes, so I recognize this was not given to us except after we filed a right to know.
May I presume that you've read this email marked at A13 prior to this evening?
Oh, I have, yes, sir.
Can you tell us what it says?
I'd rather read it.
Please.
So this is from John Weller to Pamela Garul-Bear, the township manager. Pam, I checked the municipality's planning code, and it is as I thought. The Township Planning Commission must, in capitals, be involved in the adoption of any amendment to the zoning ordinance. The MPC requires, in caps, that amendments be adopted at a properly advertised public hearing, and that both, in caps, municipal and county planning commission, be provided a copy of the amendment at least 30 days before the date of the hearing for the purpose of providing comment. The only requirement our zoning ordinance adds to this is that the time and place of the hearing have to be established by resolution. And I have no idea why. Next paragraph, which is probably the most significant. I've attached my draft memo to the Board of Supervisors rather than put it in SP. I have no idea what SP is. As we discussed, it's pretty vague. At this stage, I can't suggest a hearing date since I have no idea what they're really looking to accomplish, and the amendment isn't written. Do they want to limit on density? Question mark. If so, how much density is too much? Question mark. Is it just, quote, no apartments, end quote, which may be illegal, end quote, question mark, or a stipulation that no development could be just apartments or just residential. And while most concerned about the mall.
I want you to stop there, Mr. Kaplan, for a moment. I want to make sure we get that correctly. It says, and while we're most concerned about the mall, correct?
Correct.
Okay, continue on.
We need to consider the impact on the rest of the district. Recall that the Villas project was well received by the board since these homes will be at a lower price point and it should be pretty nice. But that's 100% residential townhouse project at a density of 12.36 dwellings per gross acre. Is that what we're trying to prevent or promote? I need clearer direction before proceeding.
Okay. On January 2nd, 2025, right around the time that Mr. Weller later told you or acknowledged that there were rumors about the mall property, Mr. Weller was noting to the township manager, quote, that we're most concerned about the mall, correct?
Correct.
I want to come back to the development of the master plan. After the January 8th meeting, and as I alluded to in my opening statement, ARD submitted a master plan on February 10th. How did that process work? How did we get from what was marked as Exhibit A10 all the way to a master plan submission by February 10th?
Because we had been very careful since the time that we purchased the property to make sure that we kept what we were doing internal. And while we didn't expect the township to be opposed to what we were doing, because it reads right out of their book, on a project like this, my advice was keep it close to the vest. Let's get a fully engineered master plan prepared so that if anything bad happens, we will be able to file our plan and vest our rights before the township can conceivably take away our rights. That was part of our game plan, and it's part of my firm's game plan in anything that we do big today, because there's just, everybody's against everything. So you have to protect yourself. So by the time we got to January the 3rd, we were 95 or more percent finished with that master plan. And we're therefore able, from the time we found out about the 6th to February the 10th when we submitted, we were able to button it up and present to Mr. Gorman on the 10th everything we needed to submit and to vest our rights under the old ordinance.
I want to clarify that's February 10th because I'm about to ask you a question about January 10th.
I'm sorry if I'm screwing up.
No.
It was February. It was January when we learned what was going on, and we knew that they were going to have a meeting on the 12th of February. So we had to file a completed plan.
Excuse me, Mr. Kaplan. Question for you. When you were keeping this development close to chest with everybody, keeping it quiet, were you concerned about the rumors that were talked about, the mall? Is that why you had that strategy?
No, I didn't. No, Mr. Cleary. I didn't know what the rumors were about the mall. No, I tried to say it at the end of my last sentence. But in today's world, in the Delaware Valley, almost every major development brings out people who are against development for real or unreal reasons. And therefore, if you're going to buy a property and spend a fortune on doing the design, get the design 99% done, so that if you get a negative reaction, as we surprisingly did, you can protect yourself.
So if there's no direct action to West Whiteland's position, but any major development like that, you have to keep it close to chest because of those problems.
I could give you a half a dozen examples off the top of my
Sure you
head.
could.
And yeah, and so could Pat, because
All right,
Pat's
thank
in
you.
the middle of many of them.
Just a quick follow-up question, and Mr. Gill, maybe you're going to ask and clarify, but when did you find out about the hearing for the 12th, and by what means?
So we did not find out at the 8th. We found out shortly thereafter. I'm trying to remember exactly who came up with it, but somebody got a hold of the minutes from the reorg meeting. And when we saw that there had been the
resolution marked at 12.
Scheduling the hearing for the 12th, we knew we had a gun in our head.
All right. You met with you called Mr. Weller on January 3rd. On January 6th, the board adopts or approves this resolution that's marked at Exhibit A12. And then on January 8th, you meet with Mr. Weller and other members of the staff. Mr. Weller says, I've got as you said, Mr. Kaplan, a bomb for you, or something along those lines. And then by January 10th, had township staff prepared a draft amendment to the zoning ordinance.
I believe so, Michael, but I've seen so much paper. Do we have that as an exhibit?
Yes, would you please take a look at Exhibit A4?
A4. Oh, yes. This is the draft of the resolution.
Okay. And again, is it your understanding that this was prepared by January 10th, 2025? Excuse me, let me rephrase that. Is it your understanding that by not later than January 10th, 2025, this was prepared?
I know it was prepared, I think it was prepared in that time frame.
Okay. All right. Is it your understanding that this is the draft ordinance, which is the result of the direction that the Board of Supervisors gave through the resolution that it approved on January 6th, 2025?
It is.
Okay. Can you please describe, excuse me, may I presume that you've reviewed this prior to this evening?
I sure have.
All right. Can you please tell us what this draft ordinance marked at A4 purports to accomplish?
Okay. Well, I've prepared some notes on that, but it's highly technical. So, and I'll try and go through this slow so you'll get the import. It deletes and replaces subparagraph B1A of section 325-13 to establish use regulations for apartments and to, prohibit single-family detached dwellings, two-family dwellings, two-family fourplex, and townhouses in the TC district. So from our point of view, they were going to stop us from our significant development of townhouses on the Sweetsford Road side of the mall.
So let's just stop right there for a moment. Earlier in your testimony, you read into the record the definition of multifamily dwellings, correct?
I did.
Is it your understanding that Section 1 of this draft ordinance would have the effect, notwithstanding that definition, of precluding single-family detached, two-family dwellings, fourplexes, and townhouses from the town center district, again, notwithstanding that definition?
It would have the effect of prohibiting the townhouses and these other types of dwellings.
Okay, please go ahead with your analysis of the ordinance, draft ordinance.
Yeah, I think there's four things. It amends the use regulations in subparagraph B2M2 of 325-13 to clarify the conditions for mixed-use buildings and only permit apartment buildings that do not have ground floor dwelling units, Section 2. So they've put a limitation on apartments. The next one, I think, is more technical. Deletes and replaces paragraph C6 of Section 325-13 to eliminate references to dwelling types prohibited by the amendment described in Section 1 above. And then, to coup d'etat adds a new paragraph 9 to subparagraph C, area and bulk regulations, to establish 6 dwelling units per acre as the maximum permitted residential density for residential and mixed-use tracts, and to exempt life care facilities and personal care facilities from that limit. So on top of everything else, they said we can only have 6 dwelling units per acre, grossly less than what's in the rest of the township and the apartments when you're left right out here on the other side of the street.
Mr. Gill, we have reached 8 o'clock. Is it now an okay time to take about a 10-minute break?
We can, yes.
All right. All right, so we're going to go off the record for about 10 minutes, and we'll be back at that time.
Thank you.
Recording stopped.
Hey, Pat, what do you got? Soda machine in?
Years of litigation in the township and other clients, all of which ended in a settlement agreement that essentially served as a basis for council and zoning district. So that Conversely, my favorite township is West Marlboro. A bunch of our clients. There is no actual, well, there is a township. Hearing the meetings are public garage, where there's folding tables, and it's huge. So when you have hearings in there in the winter, you have a choice. You have the fan blowing and keeping you warm, but then nobody can hear anything else. The border can't hear you. Or you turn off the and actually, he actually referred to it a few weeks ago. I thought he had forgotten. Back in 2013, we were co-counsel. Frankly, nearly drove me to. He had because frankly. You're on. I remember the last time we tried this. It really drove me to drink. You know. What do you mean?
No, you can't put up with the conflict. Exactly, it's the conflict.
I love the conflict. I'd much rather be in a room at 10 o'clock at night with people yelling at me.
Oh, no, that isn't what I meant. I mean, when you're in there, and you gotta say things that you have.
Oh, right, no, yeah, you're right, yeah. No, and actually, that's what I was about to say. Sometimes I find myself making really the last guy on the list. All for filling in. Kristen down to it. Kristen still does, yeah. I don't know how she does it, but she's
Yes.
and
You don't put up with it. What? Who's representing township?
Mullen.
Oh, okay.
John, I know but
Oh, yeah.
not Limerick.
I can't.
Turn Democratic. Bob, I know. Elementally. And, Bernadette. Primarily, most of us. Oh, I just got hired as special counsel. Oh, yeah. No, the one that I talked to you about. Yeah, because Marlo will travel to the ends of the earth for ice cream. Marla has cravings as if she was pregnant, but it'll be like 1 in the morning. She's like, "What ice cream place do you think is open?" Like,
Where at? What is it?
Handel's Ice Cream in Berwyn. People standing out in 10-degree weather.
Recording in progress.
Council, you ready to go back?
Sure.
All right, so we're back on the record. Mr. Gill, you can continue your questioning, please.
All right, Mr. Kaplan, Mark, when we broke, you were discussing your analysis of Exhibit A4, which is the draft ordinance that was prepared in the wake of in January of 2025. And I was about to ask you, may I presume that you've also analyzed the impact of this proposed ordinance on the Exton Square Mall redevelopment?
I have.
And what is that impact?
Well, we couldn't do the development that we purchased the property for, because it eliminates the townhouse component of the development. And then on top of that, puts in an unusually low density per acre for apartments. I mean, 6 units per acre, you can't build an apartment project on 6 units
I'm going to
per
object.
acre.
I think this is outside his level of expertise. We're getting into planning aspects, we're getting into financial aspects.
Well,
And that doesn't have anything to do with being a land planning attorney.
So let me rephrase my question,
Okay.
or try to rephrase your answer. Mr. Kaplan, your conclusion is that 6 dwelling units per acre would render redevelopment of the Exton Square Mall property impractical.
And I'm
Is that
going
your testimony?
to object to that. He's outside his level of expertise.
He's been recognized as an expert in land development and land use law. He's testified about his decades of experience representing developers.
He's not a developer.
I was going to say, can't you ask the question? What did your client say? Based upon those restrictions, did your client communicate with you whether it was economically feasible to build it?
absolutely.
And what was the result of that?
Exactly what I said. It's not economically feasible on 8 units or 6 units per acre, and it's not feasible to redevelop this property, eliminating single-family, well, townhouses, which is exactly the type of unit that ought to be in a town center. It won't work. Let me say this. John criticized, I am saying that could it physically work? Could somebody put the boxes on there? Yes. It does not work from an economic point of view.
Again, I'm going to object to
And I
any
have the
economic
Hang on,
testimony.
Mr.
Say that.
I don't
Hang on,
mind if
Mr.
it's.
Capel. Hang on, counsel. You don't get to make the determination whether or not you have the expertise or not. We have an objection. I know this is unusual with you as a witness, but you gotta let the system play out.
I've been pretty good so far.
Hang on. Mr. Walco has an objection to that testimony. Mr. Gill, do you have a response, or do you want to move on?
We'll move on.
Thank you.
After I reiterate your understanding, Mr. Kaplan, of the impact, the economic impact of this proposed ordinance upon the Exton Square Mall property is derivative of what our client has concluded, correct?
Yes.
Now, earlier, we looked at an email from Mr. Weller in which he noted that, of course, proposed zoning ordinance amendments need to be reviewed by both the Township Planning Commission and the County Planning Commission, correct?
Correct.
And is it your understanding that this proposed ordinance at Exhibit A4 was reviewed or forwarded to the Township Planning Commission?
It was.
All right. And would you please take a look at Exhibit A14?
Am I looking for the
Transcript.
The transcript. Okay.
Is it your understanding that this is a transcription of the meeting of the Township Planning Commission, which occurred on January 28th, 2025?
It is. I ordered it.
I have a moment. Please, Mr. McKenna. Mr. McKenna, members of the board, I would just ask that the board take notice of the certification on page 29 of the exhibit. Mr. Kaplan, is it your understanding that Exhibit A14 is an accurate transcription of the meeting of the Township Planning Commission, which occurred on January 28th?
It is my understanding.
You said you ordered this transcript, correct?
Yes, we did.
I'm not objecting to the certification of the transcript.
Okay, thank you.
Would you please turn to page 3 of the transcript? Is there a portion highlighted there?
There is.
What is your, who is Ms. Nardone, if you know?
He was the chairman of this township's planning commission.
And who is Mr. Kumhardari, if you know?
He was at that time, I believe, the chairman of the Board of Supervisors.
Was he also, if you know, the liaison between the Board of Supervisors and the Planning Commission?
I believe so.
And the reference to Mr. Weller there, is it your understanding that refers to the same Mr. Weller to whom we've referred throughout this hearing?
Correct.
All right. So Ms. Nardone called to order the meeting of the Planning Commission and noted that the Planning Commission had for its discussion a proposed zoning amendment to the Town Center zoning district, correct?
Yes.
Is it your understanding that the amendment to which she referred is the same document that's marked as Exhibit A4?
It is.
All right. Mr. Kumhardari, noted something to the Planning Commission members immediately after Ms. Nardone opened the meeting, did he not?
He did.
What did he say?
Let me read it. I would apologize to the Planning Commission. Normally, any zoning change would come to you guys before the board decides. But given the nature of the plans that were coming up, we needed to rush it in. Ms. Nardone says, absolutely, and Mr. Weller chimes in and says, and that's why we did that.
Mr. Kaplan, are you aware of any other plans proposed within the Town Center zoning district at that point in time, in January of 2025, other than the ARD Exton plans?
I do not.
Would you please turn your attention to page 5 of the transcript? You see a highlighted portion there.
I do, but let me just, give me a second. I just want to read a little of the context. Go ahead.
Okay. In the middle of that page 5, starting above the highlighting, on line 10, this is Mr. Weller speaking at this point in time, at this point in the transcript, correct?
I believe so.
All right, and Mr. Weller notes that staff, we certainly heard a lot of concerns from residents about the number of apartments that are going in. The board has certainly heard a lot too, and I imagine y'all, as Planning Commission members, have as well too. And then there's a highlighted portion. Would you please read the highlighted portion for us?
I believe this is John. So as Raj was just speaking, we just kind of thought, given the uncertainty of what might still be out there coming, and also the thought that it does seem that right now residential development is what sells. And so we see developers trying to kind of put things in as much residential as possible.
All right. Would you please turn now to pages 15 and 16, well, page 15 of the transcript. Now, at this point in time, a member of the Planning Commission, Ms. Kerslake, asks a procedural question. She says, okay, so now a procedural question. If we make a recommendation for some sort of modification to the proposed ordinance for the Board of Supervisors to make that change, then do they, I mean, in a hearing for this, don't they have to just consider what's before them and vote yes or no? If there's a change, does it have to be re-advertised and done again? Mr. Weller responded to Commissioner Kerslake. According to the transcript, what did Mr. Weller say?
First of all, the purpose of a public hearing is to gain public comment and to hear that. And they do have the opportunity to make changes. Now, my understanding is that you're correct. If there is what's deemed a substantive change, it would need to be re-advertised. And then that, of course, would ultimately delay the ultimate adoption of the amendment.
All right, and then I'm sorry,
Go ahead.
and then Ms. Kerslake, Commissioner Kerslake asks,
Is there
any, go ahead.
Is there any concern with delaying it? And Mr. Weller says, yes.
All right. Please turn your attention to page 27 of the transcript. Mr. Weller, well, firstly, we're reaching the end of the Planning Commission's discussion regarding the proposed amendment, correct? At this point in time, at this point during the Planning Commission meeting?
I believe so.
All right. And Mr. Weller made a comment about the proposed amendment that's highlighted there in yellow. Would you please read to us Mr. Weller's comment?
And it's also, I think it is a direct response to concerns we've heard from residents. And here it is. To be honest, it is the mall property that everyone's concerned about. And someone thinking like, what if some developer came in and just had nothing but apartment buildings? And just like, could they do that? Well, yeah, they could actually do that now, I think.
Earlier, we mentioned that Ordinance 484 was rushed. Do you recall that?
I do.
All right. At the Planning Commission meeting on January 28th, right at the beginning of that meeting, Supervisor Comhardory said that the rush was necessary given the nature of the plans that were coming up. Is that right?
I believe I read that. That's on page 3, line 10 to 16.
Did members of the Planning Commission express some desires? We heard about the reasons why amendments couldn't be made to the proposed ordinance, according to staff and the supervisor liaison. But did members of the Planning Commission express a desire to offer edits or amendments to the proposed amendment?
Yes, Ms. Kerslake, I believe, maybe Ms. Nardone. They were talking about, I believe, affordable housing, and there was no provision in this ordinance for that.
Nevertheless, and notwithstanding those concerns and suggested edits, township staff and the supervisor liaison informed the Planning Commission that any such changes should not be made, correct?
That's right. Now, to be more specific, Commissioner Member Nardone indicated she felt the proposed ordinance was incomplete and required additional provisions, including those for...
I'm sorry, I'm going to object. Just where are we referring to?
Well, I will give you the pages. Yes. Both she and Member Kerslake noted...
I'm sorry, if I could have the pages before the reading.
Okay, do we know?
Yes.
Yes.
Would you please?
17 to 18, 19, 22, and 24 to 25.
And Mr. Gill, for the ease of council, are those the sections that are highlighted?
Yes.
Thank you. Go ahead, Mr. Kaplan.
I'm sorry, what page again, please?
Starts at 17 and it goes over to at least 19.
22 and 24 to 25.
You got it. There we go. Thank you.
So there's this exchange of comments between the commissioners and the supervisory liaison and staff. The commissioners are suggesting that perhaps they'd like to see edits to the proposed ordinance, and you were going to tell us what the comments back from the supervisory liaison and township staff were. Please go ahead.
Let me, give me 1 second. Yeah, on page 18, there was a response from Commissioner Kumbahardi,
Supervisor.
Supervisor. Thank you. So if you go to the page before on line 21, Ms. Nardone says the following. I'll start because my comment on making the motion tonight is that I do not have a problem making a motion to support this amendment tonight, but I also feel that this section will require some additional too. I think the affordable housing is absolutely, the bonuses, all of those things. So I think it's a start, but it's incomplete, meaning I would expect that we would have a few more. And then Kumbahardi says, I think it's a good idea. I think we can start with this, and then we can have the hearing from Chester County Affordable Building Housing, how we want to do it, what it would be entirely, what kind of rules and regulations we can put in. We can have a lot longer time to discuss.
All right. To your knowledge, Mark, have there been any further amendments to the Town Center zoning district regulations to address affordable housing in West Whiteland Township?
Not that I know of.
To your knowledge, to your understanding, why was it so important for the Planning Commission to make a recommendation on January 28th, 2025 regarding the proposed ordinance?
Well, Kumbahardi said it right at the beginning. We have to get this ordinance done, finished, adopted, because of what the mall is going to do. So this was clearly.
I'm going to object to the recharacterization. The transcript says what it says.
Yeah, I'll sustain that objection.
All right, the transcript does say what it says. That's true.
And the board can reach whatever conclusions it wants to reach on that issue.
Couldn't say it any better than the way it's in the transcript, so you're not going to get an argument from me.
At the end of this portion of the Planning Commission meeting, the Planning Commission voted to recommend adoption of the proposed ordinance amendment, correct?
Yes.
To your knowledge, was the proposed ordinance also reviewed by the County Planning Commission?
It was.
Would you please turn your attention to Exhibit A15? You know what that is?
Yes, I do.
Would you share?
Oh,
That's what it
I'm
is.
sorry. It's the review of the proposed ordinance by the County Planning Commission.
I'm actually going to object and ask for an offer of proof as to what the County Planning Commission letter in A15 is submitted for.
This is submitted to show that the County Planning Commission had comments and concerns about the proposed ordinance, and notwithstanding those concerns, consistent with the statements that were made at the Township Planning Commission and the entire course of conduct, the Township apparatus, including the Board of Supervisors, rushed to adopt Ordinance 484 rather than respond to these comments.
Unless he's going to present evidence that shows that the Board of Supervisors always changes their ordinances based upon the County Planning Commission letters. I don't see the relevance of it.
The Zoning Hearing Board can certainly draw implications and inferences from the evidence, including everything that we've talked about so far, and including the comments of the County Planning Commission and why the Board of Supervisors did not respond to these comments.
Yeah.
I don't understand why the Board of Supervisors would need to and how that reflects on the validity of the two ordinances.
Understood, and you're free to put on any evidence that you would like to also support that theory, but I think we're going to overrule the objection, and the board can afford whatever weight they'd like to for the review letter.
Thank you. Now, we have highlighted some portions of the county review letter, correct?
Yeah.
And you've reviewed those highlighted portions prior to this evening?
Yes.
Would you please tell us what the County Planning Commission's comments were, focusing please on the highlighted portions?
Go to the second page. While not inconsistent with the objectives of the suburban center landscape, proposed standards would be more consistent if the township continued to allow a wider range of residential housing types in the town center mixed-use district, in addition to non-residential uses at appropriate densities. And then on the next paragraph 3, prior to taking action on this subdivision, the township should consider whether this proposed amendment is generally consistent with the township's comprehensive plan as set forth in the section 603J of the Pennsylvania Municipalities Planning Code. Farther down in that paragraph, the comprehensive plan indicates that the intent of the town center mixed-use category, which, quote, illustrates the continuation of the township's long-standing policy of accommodating our highest intensity of development, end of quote, is to allow a mix of residential, commercial, institutional, recreational, and office uses designed to facilitate pedestrian and bicycle travel. Paragraph 4. Townships should identify their rationale for the proposed 6 dwelling unit per gross acre maximum permitted density for apartment development. The township's comprehensive plan states that while the township does not specify a maximum density for town center mixed-use category, the township anticipates that residential density will exceed 8 dwelling units per developable acre allowed in the high-density residential category. And finally, we note that the proposed density is significantly lower than the existing apartment development in the district. The township should determine how many existing residential uses would become non-conforming if the amendment is adopted as currently written. And then over on the next page, we recommend that the township consider maintaining townhouse development as a permitted use in the town center district. Townhouse development is an appropriate use in the suburban center landscape and the suburban center landscape use guidance in the planning principles section supports new housing inclusive of a broad range of housing types and income levels. Page 36. Last one. We note that West Whiteland Township is undertaking an update to its existing comprehensive plan, which is being prepared under the Chester County Vision Partnership Program. We recommend that going forward, the township delay additional major amendments to the township zoning ordinance until after the comprehensive plan update has been completed and the new land use policies have been established.
Thank you. To your knowledge, did the township ever explain, as the Chester County Planning Commission requested or suggested, the rationale for the proposed 6 dwelling units per acre?
No.
Did the County Planning Commission's letter have any effect on the township's march toward adoption of Ordinance 484?
No.
Did you attend the Board of Supervisors, did the Board of Supervisors hold a public hearing on the proposed ordinance amendment on February 12th, 2025?
It did.
Did you attend that hearing?
I did.
On behalf of our client, did you raise concerns with the Board of Supervisors regarding proposed ordinance 484, what became Ordinance 484?
I did, rather emphatically.
Prior to the hearing, did you submit written comments to the township for the Board of Supervisors' consideration regarding what would become Ordinance 484?
I did.
Would you please turn your attention to Exhibit A16?
I have.
What is that?
It's my email of February 11th to at least Pam Gruhl, Bear, Pat Corman, John Weller, Sean Kilkenny, Alex Baumler, and some other people that are non-township. You want me to read this?
Why don't you just summarize it for us?
Well, I feel better if I just read it.
You may do so.
As I indicated in my email to Alex and Sean, I represent ARD Exton Square LLC, the equitable owner of the Exton Mall property, and that it is my opinion that the adoption of proposed Ordinance 484 by the Board of Supervisors of West Whiteland Township tomorrow night will constitute invalid special legislation. Therefore, we have prepared the attached challenge to the validity of the adoption of that ordinance and will file it on Thursday if the ordinance is adopted. As you know, yesterday, ARD Exton Square filed with the township a very extensive application for approval of the master plan for the property, as required by the township's town center zoning district. Because the master plan is a required filing in the TC district, long-standing Pennsylvania law, that filed master plan is the equivalent of a preliminary plan and is protected against any after-adopted zoning amendment by the provisions of Section 5084 of the MPC. In addition, because the town center district states that the filed master plan is to be reviewed and approved as a conditional use, it is also protected against any after-adopted zoning amendments by the provisions of Section 917 of the ordinance, of the MPC. I raise the effect of Sections 5084 and 917 of the MPC because it's my opinion that our master plan is vested, and ordinance 484 will not affect my client's ability to obtain approval of the development depicted on the master plan. However, what it will do is make the redevelopment of the mall non-conforming because it will contain townhouses, and its total residential component will exceed 6 units per gross acre. The adoption of ordinance 484 will also make other apartment developments in the township non-conforming. That does not seem like an outcome that either the township, my client, or the owners of other apartment complexes in the TC district will welcome. So as I said in my prior email, we ask that you recommend the Board of Supervisors they reject this ordinance. Whether or not the board adopts or rejects ordinance 484, ARD Exton Square team looks forward to working with the township so that the mall can be redeveloped in a coordinated manner and in accordance with the TC district.
You mentioned that was sent on February 11th. On February 12th, the board held its hearing. And did the board adopt as ordinance 484 the proposed ordinance that is marked in our binder as Exhibit A4?
They did.
Now, we did not immediately thereafter file the substantive validity challenge that we're here about tonight, correct?
That's correct.
Why not?
Well, because John Weller and Alex Baumler, the township solicitor, made a decision that our plan was vested and that it should be reviewed in accordance with the prior ordinance. And as we moved on, there was excellent cooperation between the staff, John, Pat, whoever else was involved, Pam, to some extent when Alex was involved. So we were moving forward thinking that, okay, they adopted it, let it sit. If we get approved under the old ordinance, we're fine. And we didn't want more aggravation. We didn't need more tumult. So we went ahead with the processing of the plan.
All right. Now, you mentioned a moment ago, Mr. Weller's conclusion that the master plan as submitted on February 10th was vested and would be reviewed under the ordinances as then in effect, correct?
Correct.
Would you please turn your attention to Exhibit A1I?
And Mr. Gill, this was an exhibit that was featured as your packet with the application, not exhibit tonight.
It is. It's part of the challenge that, as filed.
Okay. Do you want me to bring that up or?
We can. Mark's just going to testify about it very briefly in just a moment.
Okay.
So I don't know if we need to have it on the screen or. Do you recognize this document, Mark?
I do.
Can you tell us what it is?
I believe it is John Weller's first review of our first set of master plan drawings.
All right. And in this review, did Mr. Weller reach a conclusion about the applicability of Ordinance 484 to the master plan review?
I did, but I gotta find it. A long, long letter.
Why don't you turn to page 11?
Okay. Just found it.
Or found it on page 4. Would you please turn your attention to page 4?
Bottom of page 4. The zoning is consistent with the comprehensive plan, providing details about what specific uses are allowed and regulating the size and arrangements of the buildings. This master plan was submitted before the effective date of the most recent amendment, which limits residential density to not more than 6 dwelling units per gross acre and dwelling type to apartments. Staff is of the opinion this criteria has been met.
All right. Would you please also would you please then turn your attention to Exhibit A1J? In particular, page 2 of that document. Are you there?
Yeah.
Did Mr. Weller reach any conclusions regarding the master plans as submitted and revised compliance with the zoning ordinance criteria applicable to master plans?
Yeah, this is his August 15 review of probably our 3rd version. And in the middle of page 2, he says, mixed-use developments are permitted in the TC district by 325-13B of the zoning. And all of the specific uses shown on the master plan are permitted by that section. The zoning officer has further determined that this project complies with the applicable standards of 325-13C and D.
All right. Would you please next turn your attention to Exhibit A1K and tell us if you recognize that document?
It's the Thurkoff memo in September.
All right.
I believe after the Planning Commission.
All right. And this was a further review of the master plan submission as revised, or as
Correct.
being reviewed by the township, excuse me.
Correct.
All right. Did Mr. Thurkoff, would you please turn to page 8 of the document?
Yes.
Did Mr. Thurkoff reach any conclusions regarding the architecture of the master plan?
Architecture, section 325-13.
So just as a matter of saving time, I'm just, again, going to ask for an offer of proof as to what I imagine would be going through the review letters of the master plan. Again, my understanding was this hearing was going to be about the ordinances and not the project and the master plan. So I'm asking for an offer of proof as to relevancy to the ordinances.
Again, we're here talking about a scheme or an intent of the Board of Supervisors to ultimately reduce the amount of, or to reduce the type and density of residential uses at the property. This all goes to establishing that intent. That intent was manifested certainly no later than January of 2025, and the Board of Supervisors' action and its comments, the comments of the members of the Board of Supervisors surrounding the denial of the master plan, all go to that intent.
Well, I would agree that if the plan was not vested, these letters would be relevant, but the plan was vested. The plan was filed, where the ordinance or an agreement does not apply to this plan. As the memo said, as Mr. Ballmer apparently spoke with Mr. Kaplan previously. So why does any of this review of that plan? Because if both parties are in agreement that this plan is not impacted by this ordinance amendment.
But therein lies the rub. If the denial is upheld, notwithstanding the consultants and staff's comments, and given the comments of the Board of Supervisors members surrounding that denial, then Ordinance 484 would apply to the development of the Exton Square Mall property.
Well, then, and I would submit it's not right. at this point. There's no actual justiciable issue for this board. This ordinance does not apply.
That is
this plan. And if it's a bad plan and it's upheld that it was a bad plan and should not have been approved, then the Court of Common Pleas, Superior Court, Commonwealth Court, not the zoning hearing board, is the one to make it.
And now Mr. Walko is getting into the merits of the underlying plan.
I think we understand the objection. I think it's relevant to the applicant's theory. Whether that theory carries water and carries the day is up to the board, and you are certainly welcome to put on evidence to contradict that theory. But it seems relevant to me as to their theory and potentially as to credibility determinations of the actions of the township that have yet to be made by the board, depending upon the witnesses that you put on. But again, as to the applicant's theory, it seems certainly relevant for the course of conduct that they're trying to establish. Whether or not the board agrees with that, I think, is the ultimate issue here. So I hear the objection, and we're going to overrule the objection and permit it.
All right, I think, Mr. Kaplan, you were referring to and describing Mr. Thurikoff's comments at page 8 of his review memo. Please continue.
Architecture, section 325-13E2B, the zoning ordinance requires that the master plan demonstrate compliance with the architectural standards of section 281-67 of the Saldo, specifically with regard to 3 different aspects of the buildings. The operative sentence is the architectural precedent imagery in the plan set demonstrates conceptual compliance. The land development and/or building permit plan shall include documentation as necessary to confirm.
Would you please next turn your attention to Exhibit A1L and tell us if you recognize that document?
Scott Stevens and McCoy, Township Engineers, review letter, dated August 8th, 2025, just before the final Planning Commission meeting.
And did Spot Stevens and McCoy offer any comments or conclusions regarding the master plan's compliance with certain township ordinances?
Yeah, well, this was its 3rd letter. As a result of the meeting, it is our opinion that the stormwater management concept as currently presented demonstrates that the detailed design to be completed during the land development plan approval process will be capable of meeting the applicable provisions of the West Whiteland Township Stormwater Ordinance, subject to some number of comments that will have to be complied with. So that was Spot Stevens and McCoy's sign off.
All right. You've already referred several times, as did I during my opening statement, to the Board of Supervisors hearing on the master plan application. That occurred between September 24th and October 22nd, correct?
Yes.
And what was the result of the hearing?
Well, one of the most important things that I'm not sure we accurately covered is Mr. Weller submitted a September detailed memorandum that we might have touched on, but we didn't bring to the attention of the board, where he went through each and every aspect of our compliance with the zoning ordinance and the Saldo, and said we complied with everything. Notwithstanding that, to our surprise, the 2 supervisors went out and had some kind of meeting, came back in.
I'm going to object to whatever he's referring to. He's just accusing the Board of Supervisors of potentially having illegal actions.
Well, I don't think we got to that point. I understand what you're suggesting. He didn't suggest anything untoward. I'm not taking it as anything untoward, and there was no testimony as to their conversations. I think it's simply based on an observation. They left the meeting, the two of them.
So let's clarify that. Mr. Kaplan, at the conclusion of the evidentiary master plan hearing, take a step backwards. Were you present at the conclusion of the evidentiary hearing?
I was.
On October 22nd, 2025?
I was.
At the end of the evidentiary presentation, did the two members of the Board of Supervisors retire into executive session?
They did.
Okay. Did they then return from executive session?
They did.
What happened next?
They rejected the plan. Looking at this transcript, just give me a second.
Sorry, Mr. Gill, which exhibit were we referring to?
No, I, that wasn't what he was asking me about. At the,
I'm sorry, Mr. Kaplan, which exhibit are you referring to for reference?
I don't think he's referring to any specific exhibit at the moment.
not, at the end of the meeting, as I said, quite frankly, we expected the board do what I had been told is their normal procedure. They would close the record, they would have another meeting, they would tell the solicitor to prepare a decision, and there would be a decision in another meeting. To my surprise, the two of them went out, came back, and very quickly voted to reject the plan without really any explanation whatsoever, without any deliberation.
Would you please turn your attention to Exhibit A1N?
And looking at, I'm going to object, or at least ask for an offer of proof of A1N. This appears to be an article written by a third party that has quotes from a non-witness. And I understand hearsay is permissible at zoning hearings, but hearsay within hearsay should not be. And I think it'd be opening up a really hard door and a horrible door if this board would allow newspaper articles to be brought in as evidence as to what people say when those people aren't here testifying.
Yeah, and this is squarely and clearly, if it's not an admission, it's a statement against interest for on page 1, 2, 3, on the fourth page of Exhibit N. Excuse me. On the third page of Exhibit N, at the bottom, we have a reference to township documents that Mr. Weller wrote. And then on the next page, we have statements by members of the Board of Supervisors. It is those statements that we're going to be
and again,
discussing.
I'd object to that. I mean, it's one thing if one person could testify to, I heard these people say this, even though it's hearsay, it's permitted at a zoning hearing. But to bring in an article that says these people said those things, that's double hearsay.
These are quotes.
Allegedly. Allegedly.
These are quotes from members of the Board of Supervisors, the governing body of the township, which is a party to the proceeding. If Mr. Walko would like, he can call Mr. Dunn and the other supervisor, Mr. Comharty, to testify about these comments and to refute them if they'd like, if they're able to,
Or I'll have my friend write a blog and make up some quotes and bring in that blog.
And again,
I mean, that's...
Hang on, let Mr. Gill finish.
These are exceptions to hearsay. They are statements against interest. They are admissions by members of the Board of Supervisors, the governing body of a party to this proceeding. If Mr. Walko would like, he can call these members of the Board of Supervisors to refute these statements.
That's not my burden. It's his burden to prove it. He's doing it with double hearsay. If he wants to call members, he certainly can. If he wants to call the person who wrote this article that says, I spoke to these people, that's what they said, that's fine. But to just bring in a piece of paper written by somebody else that says these people said these things, that's double hearsay.
But Mr. Walko
It's not reliable.
But Mr. Walko still hasn't addressed the fact that there's an exception to the hearsay rule for statements against interest.
Not double hearsay.
Understood. Give me a second. I want to discuss it with the board. Go off the record, please.
Recording stopped.
Very limited question. I know. I get the risk. I get the risk. What are you sitting there?
All right, I'm back.
All right, discuss the
Recording
nature of
in
the
progress.
objections with the board, and I understand the objection, but they're going to overrule the objection and permit the testimony on the exhibit.
All right, then, Mr. Kaplan. Mark, would you please turn your attention to Exhibit A1N? And again, the fourth page of that document.
Fourth page at the bottom of the third.
It's the page with a, what looks like a detail of a map of West Whiteland Township. So. First of all, before we get into that, I neglected to ask you because of the objection. Have you reviewed Exhibit A1N prior to your testimony here this evening?
I have.
And is it your understanding that this is an article written in the Philadelphia Business Journal following the board's action denying the master plan?
It is.
All right. In the article, the two members of the Board of Supervisors are quoted as making comments or reported as having made comments regarding the master plan application, are they not?
Correct.
Would you please tell us what the article says?
Well, if you go to the bottom of page 3, it says West Whiteland Township Director of Planning and Zoning, John Weller, wrote in township documents that the plan complies with zoning. The Township's Planning Commission unanimously voted in August to recommend the Board of Supervisors approve the plan. When you go to the top of the next page, quote, that's an advisory board to advise to the supervisors what's going on, Dunn said of the Planning Commission. Quote, that's all they are. We have a good Planning Commission. Don't get me wrong. And then you go down further, says, while the township staff was, quote, satisfied with Abrams' plan to improve stormwater management, township documents show Dunn and Kumbaharty said the township doesn't have the sewer capacity for the project. Kumbaharty said his biggest concern was the density that the project would add. He said he received hundreds of emails from residents concerned about the increase in traffic that the project could result in. The property sits at the intersection of 30 and 100. Both Kumbaharty and Dunn said they're open to a revised plan from Abrams with less density. Kumbaharty said an updated plan has to work for everyone. I think that's all of the quotes from the two supervisors.
All right. Kaplan Hardy in the article is noted to have mentioned 300 emails which he received from township residents, correct?
That's correct.
Well, hang on. I think what he said was hundreds.
Excuse me, hundreds.
Thank you.
Received hundreds of emails. After this article was published, did ARD Exton, through your office, complete a right-to-know request to the township?
We did.
As part of that right-to-know request, did ARD Exton seek those hundreds of emails?
We did.
What was produced in response to that request?
We received 2 responses to that request from, I don't remember whether it was the solicitor's office or the township. We got some documents, some of which we've talked about tonight, some of Weller's memos, and we didn't receive any emails. Then we got an email from the right-to-know officer said, oh, there's more, we'll get them for you. They got us whatever they got us. There were no hundreds of emails. In fact, there were no emails given to us. And I heard Mr. Cumbaharty say there were 300 emails in this room as a reason for turning us down.
All right. Now, will you please turn your attention to Exhibit A10? After the board denied the master plan on October 22nd, 2025, did you come to learn that Supervisor Dunn was an interviewee on a show called The Morning Show on WCHE?
I listened to the interview.
All right. And did you order a transcription of that interview?
We did.
May we have a stipulation, given the certification as to the accuracy of the transcription?
I won't be stipulating to this, as I'm unfamiliar with the radio program transcript, so please certify.
I'm sorry, you will stipulate?
No, I will not stipulate to this one.
Okay. Mark, would you please turn your attention to page 19 of this manuscript of the interview?
Yes.
And do you see there a certification of the transcriptionist?
I do.
All right, and that's signed by the individual who transcribed the interview, correct?
Correct. But I listened to this. I heard the interview.
Okay.
This is as accurate as my memory can recall.
Okay. Nevertheless, well, I'm very interested in and certainly respect your recollection. Could you please confirm that the transcriptionist is certifying the accuracy of the transcript in this certificate?
Yes.
Okay. And
I'm going to object again for foundation. I'd like to know how the audio recording made its way to a transcriptionist that was arranged by Mr. Kaplan.
all right, Mr. Kaplan, would you care to address that?
I ordered it.
I understand that, but what does that mean? You ordered it. You
I
call it.
ordered
In other words, the transcript didn't exist. There was no court reporter. Hang on, during the time there was a show you listened to. So how did what was broadcast get to the court reporter to be transcribed?
The program was transcribed by the radio station. You were able to go on their site and get and download the interview.
So in other words, you were able to download a audio recording of it?
Now listen to it.
So I'm sorry, do you agree that's what happened? You downloaded?
Absolutely. It was an audio recording of the interview.
And then you take that audio recording and you give it to this court reporter to transcribe. Is that what occurred?
Correct.
And we can provide another witness in addition to Mr. Kaplan who can testify about that chain of custody, if you will, of the audio of the interview.
That won't be necessary, as
We don't need
there is as
Well, if he wants to.
Thank you.
Well, I'm sorry, is there a stipulation as to the accuracy of the transcript then?
I'm not going to stipulate to the accuracy, but I'm not going to object to the.
Okay.
We're introducing.
All right, Mr. Kaplan, you listened to the interview and you ordered the transcript of the interview. Would you please tell us what Mr. Dunn said during the interview regarding the bases for his vote to deny the master plan application?
Let me find out where. See where my notes are on this. So he is asked, Speaker, I'm sorry, Supervisor Dunn, can you give us any insight on this project?
Sorry, where are we, gentlemen?
I'm reading the mini page 2.
All right. Now, I'm hoping, Mr. Kaplan, you don't intend to read the entire transcript because we can do that ourselves.
No, I don't.
Thank you.
Kind of concept and why it got turned down and all that. Can you give us some insight? Mr. Dunn? I mean, it's pretty much what you've been hearing, Main thing is, sewer capacity. Is they've been dancing around it and keep hitting them with it like you don't have the sewer capacity, and they kind of danced around it, kept going forward, trying to go forward with it. And if you put in infrastructure in like that massive. Speaker interrupted, that just seems to me. Dunn then says, I mean, market space is short, the schools would be drained. The surrounding structures, if they wanted to, try to, grow or do anything, A lot of that would be maxed out, with this particular project in the area. It could costly to the residents. It goes on, you can read it. We never heard about sewer being a problem before. We put evidence in from the township that there was capacity and that the Downingtown area plant is being increased in size. So you have Dunn talking about sewer capacity. You have Kimball Hardy saying, I know the density complies, but I don't like the density. What was the other thing? Oh, and they don't like the traffic. But there was no need for a traffic report at this stage. But we had a traffic report prepared. We had it reviewed by the township's traffic engineer, and he concluded that with the improvements, it was fine. So I sat here and watched all these months go by when everybody else in this township was cooperating and were trying to get this done. And two people, for whatever reason, turned us down without any discussion. And then
Again, I'm going to object to without any discussion. There was testimony previously that they had discussion in executive session.
Doesn't matter
Sustained.
whether there's discussion or not. We described it already. And for all this time, trying to get the answers of why, we couldn't get the answers.
So, Mark, I'd like to bring this point home. Would you please turn your attention to page 8 of the mini script of the interview.
Go ahead.
Now, a person identified as speaker one, who I presume is the interviewer, said to Supervisor Dunn, "Yeah, that's a problem too. So, what do you do there? Has anybody considered that of just retrofitting the mall into something else?" And Mr. Dunn responded, "How?" Would you please read that particular response into the record?
Page 8.
Page 8.
Done. Don't know, don't know. I mean, the concept of what they want to do isn't a bad idea. It's all good. It's just too much as far as my, like, if I'm concerned, I think it's just way too much.
Okay. Now, the second component of our challenge to the validity of components of the zoning ordinance, is with regard to the moratorium on amendments to master plans, correct?
That is correct.
All right. What objections or what concerns do you have about the 5-year prohibitions in section 13E, 5D, and E of the zoning ordinance?
I'm going to object to whatever Mr. Kaplan's objections are. He's not the property owner. He's the attorney for the property owner. I don't see how that's relevant.
Yes, he's legal counsel for, and attorneys are recognized universally, as far as I'm aware, as agents for their clients.
All right, but what's the offer of proof here? What's his testimony to elicit? Because are we going to the ultimate issue here, which is what I'm concerned about, that the board needs to decide?
Yeah, so in a manner of speaking, and if we can all recognize, perhaps we can, that this is a pure issue of law. We're challenging the 5-year amendment prescription as being facially invalid. So I don't disagree. To a very large extent, there are no facts that are necessary for the zoning hearing board to resolve that question of law.
I disagree.
All right.
Hang on, Mr. Kaplan. You're not counsel right now. You're a fact witness. You got to wait for a question. Go ahead, counsel.
I disagree. I mean, it's our duty to ensure that there is this amendment from 2020, mind you, that it was based upon the health, safety, and welfare, proper zoning permitted under the MPC. These are things that we intend to introduce based upon facts when we call our witnesses in chief in order to defend our ordinance. And again, based upon the facts that we'll present, we will make an argument in law.
Yeah.
So may I have a moment?
You can have a second. Yeah.
Thank you very much.
Recording stopped.
Mr. Gill, we're back on the record.
Recording in progress.
Would you like to add anything further?
Yes, I had. Mr. Kaplan, you testified earlier that not only do you represent ARD Exton, but you also represented the prior owner of the Exton Square Mall property, the Pennsylvania Real Estate Investment Trust. Is that correct?
I did.
And during the course of that representation of the prior owner of the mall, did the moratorium provisions of the master plan regulations create any issues for that prior owner at that point in time?
Absolutely.
Would you please describe those for us?
Absolutely, and they were discussed in this room with multiple members of township staff, John, et cetera. The problem is, and it was even more severe 3 or 4 years ago, before the retail market had come back, it was difficult enough to come up with a master plan looking in the future of who the users were going to be and spend a lot of money on that. And then You're locked in for 5 years. You're not allowed to make.
I'm going to object. Again, these are opinion testimonies related to
No,
the
these are-
appropriateness
Hang
of
on.
the ordinance based upon a representation of a non-landowner prior client. That's not the party that's before you today. I think he's testifying as to why he thinks this ordinance is invalid, and that's the ultimate decision before this board.
No, he's testifying.
I'm testifying.
Hang on, Mr. Kaplan. You don't get to answer. I know this is difficult for you,
Sorry, Pat.
but I need you to hear me. You're a fact witness. So stay in your lane and let Mr. Gill, who's very capable, respond to the objection, please.
He's not testifying about the ultimate issue. He's testifying expressly about facts and meetings and discussions in which he participated, both with his then client, obviously not betraying confidences, and with members of township staff and other township representatives. Those are the facts that he's testifying
Well,
about.
then I asked that talk about the meetings then and what was told to him by his clients.
Yeah, so I'm going to allow that aspect, right? So you're going to tell me what the problems were with that developer related to the ordinance. What I don't want you to do is conclude the legal side on the ordinance, because that is what this board has to decide.
I am trying to stay away.
So if you want to talk to the facts of what the difficulties were for them related to the ordinance, I think that's proper. We can do that. Go ahead.
So in the early stages with PREET and with ARD of trying to come up with a master plan that is a projection of what's going to be built out over a number of years. Okay, we take our best guess at that. But then for a developer to be locked in to that plan for 5 years, and then if you get it amended later, you're locked in for another 5 years, it makes it impossible to compete in the market because the market changes all the time. So this locking in, forget about legal or not legal, it's an incredible impediment.
Objections for
Okay.
testimony.
But let me ask you this follow-up then. If that's the case, why did ARD file with the ordinance in that manner, knowing it was going to have this 5-year impediment and you thought you were going to get approval? So why would it have subjected itself to the ordinance that you're now challenging?
Maybe we were fooling ourselves, Pat. We thought that because I was part of that, the design of that, we thought that we had come up.
Excuse me, Mr. Kaplan, real quick.
Excuse me.
No, you have to get next to the microphone.
Oh, I'm sorry. We thought that we had come up with a plan that did exactly what the ordinance wanted. And unlike PREET, who couldn't lock itself in on a master plan, we were willing to lock ourselves in to a master plan on practically every aspect of it. We thought that we would be welcomed with open arms, and the provisions that had been imposed because of the really bad relationship between PREET and the township would go away.
Well, then wouldn't you agree, though, that the actions that they were taking, what you're suggesting, are somewhat inconsistent with the argument you're making now? In other words, wasn't the ordinance invalid at the time you filed the application? The language was no different than it is now.
But
And if we would have had to, we would have challenged it. But we thought that we would be welcomed with open arms, and that restriction that had been put on PREET because of what PREET had done would go away.
Is that typically what happens? Are you typically welcomed with open arms?
In a situation like this, where you have a deteriorating mall and taxes that are dropping and dropping, and where this township brought in, they did charrettes with the American Institute of Architects or whoever it was on the mall. And they had all kinds of, they had said they want the mall redone. We were blown away. We were blown away when we heard that there was some problem with what we were going to do.
More to the point, directly to, in response to your question, Mr. McKenna, which, as I understand it, is why did the applicant submit a master plan application if the applicant had concerns about the 5-year moratoria provision?
Well, I guess it's more finely tuned than that, which is the language you're challenging now is exactly the same language that you submitted yourself to and thought you would have no problems
But
complying with.
Not complying with.
Hang on, you said, and then you said it would be difficult, I forget exactly what your language was, with that 5 years because the plans, markets change.
But Mr. McKenna, firstly,
Can I talk for myself, please? I didn't say that we could live with it. I said that it's a provision that would be a big problem. And I sat in, now this is my personal knowledge, I sat in this room with John Weller, with the prior township manager, a whole group of people, when I was representing Preet, to when we were finally talking and we were going to do a master plan, and the discussion turned to getting rid of this. And there was, I won't say everybody said yes, but they understood why it was such a problem. We thought that we would be welcomed, and therefore, if we had a problem with this, it would be amended and eliminated.
Okay. Following up on what I was saying, Mr. McKenna, first, so there are 2 points. Number one, the applicant did not have a choice. The applicant had to submit a master plan. Whether the applicant agreed in January or February of 2025 with the 5-year moratoria provisions was irrelevant to the applicant's obligation to present a master plan. So the applicant, to follow up on your question, the applicant was faced with a Hobson's choice. If the applicant had a problem with the 5-year moratoria and said, well, we're not going to submit ourselves to it, then the applicant couldn't comply with the ordinance, generally speaking, because it couldn't submit a master plan. And then,
well, I guess
regardless,
couldn't them, as an equitable owner, couldn't they have challenged the ordinance before filing?
it could have, but that does not, the absence of a challenge at that point in time does not somehow, through alchemy, legalize an otherwise unlawful provision.
But I'd argue that the position they're taking is there's nothing wrong with the ordinance if they would have welcomed us with open arms. And that's not about the ordinance.
Well, and that's argument, and I understand that point, and that was kind of the question I was getting at, which is, had you been granted, would there still have been an invalid ordinance? But I think Mr. Kaplan answered my question, which is, we had the sentiment that the project was going well, and if there had been a speed bump, they would have asked for an amendment, either of the ordinance or somehow to address that. And that was, I think he answered my question.
But there's a final point. The absence of that eventuality, the fact that that is not how things played out, does not render an otherwise unlawful moratorium somehow lawful.
And I'm not suggesting to the contrary.
Okay.
That's not why I asked it.
Thank you.
It is 9:30. I don't know if you have more questions for Mr. Kaplan tonight, if he's done, or if you'll be done soon, such that we could wrap at least his direct up when we come back in February.
Can we take a very brief couple of minutes?
Sure. Why don't we take 2 minutes and find out where you're at?
Thank you.
Thank you. Go off the record.
Recording stopped.
around.
Anyway, whatever's in there, we can always.
Ready? Michael, are you ready?
So,
Hang on, are you ready to go back on?
yes.
Recording in
Go back on the
progress.
record.
All right, Mr. Kaplan, you testified.
Well, hang on, are you going to try to wrap him up tonight?
I am.
That-
I'm asking,
Maybe 10 more minutes? kind of thing?
not even,
Great, let's do that. Thank you.
asking an ultimate question here. Mr. Kaplan, you testified tonight both as a fact witness and as a qualified expert. Have all of the answers to the questions that have been posed to you tonight been given to a reasonable degree of certainty in your field of expertise as recognized by the Zoning Hearing Board at the beginning of the hearing?
Yes.
Thank you. I have no further questions for Mr. Kaplan, but I reserve the right to recall him on rebuttal.
Hey, Mr. Walker?
Obviously, no further questions tonight, but was he sworn in? I wasn't sure if he was.
Yes, he was sworn in earlier.
Okay, thank you.
All right, so what we're going to do, we're going to pause the hearing tonight. We're going to continue the hearing until Thursday, February 26th at 6:30 p.m. That night, the first order of business, the board has to render a decision on another application. It should take literally 5 minutes. And then we're going to come back to this hearing. At that time, the township can start their cross-examination of Mr. Kaplan and the board. After that, if they have any questions, we'll get to them. And then, Mr. Gill, if you have any redirect, we'll do it at that time. I'm assuming if you don't have any other witnesses that you'll wrap, and then the township will begin their case in chief that night.
Can I ask, John, do you have cross-examination for me?
I would be shocked if he didn't, Mr. Kaplan. So we'll plan on it.
Is there a problem with availability?
I'll have to figure it out.
Okay, so we're going to come back on the 26th. Perhaps, council, what we can do offline, I don't know how long you're going to be that night, but in the event that we don't finish on the 26th, I don't want to meet on our regular meeting night in March to interfere with other applications. So perhaps what we can do offline is just maybe circulate, even if we don't use it, a third night date for hearings in case we need it.
I think probably based upon the fact I'll be calling Mr. Weller, and you heard a lot of fact testimony. I'm sure they're going to have cross-examination of him as well.
Yeah.
That's a likelihood of a third meeting.
And that's what I assumed too. So offline in the next week or so, let's see if we can't coordinate on a third night just to be safe.
All right, and just for good measure, because I very well may otherwise forget, we'll move into evidence exhibits A1, inclusive of all of the subparts, through A18.
No objection to the omission based upon my prior objections.
Understood. They'll be admitted.
Thank you.
Thanks, everyone. We'll see you next month.